Hannah Mackey on behalf of Mr. Howard.
Oh, the shoes match too.
My nails too. They all match.
Oh, I was going to do that. No, God. Go ahead.
Please state your name for the record.
Dalton Howard.
Thank you, sir.
Your Honor, request an adjournment. We're waiting for discovery. Our office has not received any yet.
Discovery.
Yet.
The adjournment, I believe that has put through the discovery process. So.
July 17th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Right. So all I have left is. Court does call the case of People versus Garrett.
Panagle, Your Honor.
Panagle, of course.
Assistant Public Defender Jay Bellinger on behalf of Mr. Panagle, who approaches. And Mr. Panagle, can you please state your name for the record?
Here, Panagle.
And Your Honor, while I can say that my client is not awaiting the rapture, he is awaiting a response as to.
You really didn't have to, but go ahead, sir.
He is awaiting a response as to 20 seconds recovery court. I just submitted him for that yesterday. I was informed by Ms. Sample that he will have an answer no later than the 24th, and at which time I imagine we'll have some sort of resolution going up. I'm hopeful.
So is the answer, you think, coming on the 24th?
I think that they meet on the 24th,
Got it.
so I believe it will be.
Okay. So what I'll do is I'll adjourn this out to July 31st.
Thank you so much.
At 9 a.m. bond will continue.
I'll have an answer for you by then.
Oh, she's using her big words, asking me if we're doing recalls. Apparently we are.
Thank you, Your Honor.
Thank you.
I got you.
I'm doing all this. What? Are they ready? Do you know if they're ready? Or you just hand it? What?
I'm voting insurrections.
I won't call what I want.
Oh my.
I know. Court calls case Tyler People versus Tyler Redmond. Gail's ready.
For the people here.
I'm just here.
Yeah, the Assistant Public Defender on behalf of Mr. Redmond, Your Honor. Mr. Redmond, state your name for the record.
Tyler Redmond.
Your Honor, we're still waiting for an assessment to be done from the Circuit Court Sobriety Court. At this point, I would ask the court to, we thought it was
the 22nd.
Yes. Yeah.
Sobriety court.
Yeah. At this point, I'd ask the court to set an exam, and we'll continue to look into that option as well. I've talked to the assistant prosecutor, and I've told him that if there is an assessment done and we're in a position to waive or resolve, I'll certainly give him notice in ample time to call if any witnesses.
So he hasn't even been assessed.
No, Your Honor, we thought that was going to happen by the 26th, and I think they're a little bit behind.
So you want an exam instead of adjourning it to see if you can make that happen? I mean, either way, it doesn't matter to me. But.
If we have the exam, I can still do the assessment.
Let's set an exam, Judge, if the court's okay with that.
No, discovery is complete to your knowledge.
Yes, Judge, to my knowledge.
People have their witnesses available the 15th.
Yes, Your Honor.
Preliminary examination in person, July 15th, 2025, 9 a.m. That is before Judge Moore.
Assessment is also.
Yeah.
Okay.
Okay. All right.
Bond continue.
Thank you, Your Honor.
I'm sorry. Jeez. Get ready. No. Court calls case People versus Lakita Roberts.
Here, Richmond, Deputy for the People.
She do.
Mike Getty, Assistant Public Defender on behalf of Ms. Roberts, who's here to my right. Your Honor, state your name, Ms. Roberts.
Lakita Roberts.
Thank you.
Welcome.
Your Honor, I'd ask to set this matter for an exam.
For exam,
Yes,
all discoveries complete.
I have reviewed the file. Looks like it is, Judge.
I believe so. I did want to just confirm with Mr. Getty.
I'm happy to talk about a global resolution. I've spoke with Mr. Ward about that as I was instructed to do, and he and I are going to continue talking, Judge.
People have their witnesses available this 15th.
I'll move to Robert's.
If I can be
Their
heard,
examination in person, July 15th, 2025, 9 a.m. That is before Judge Washington.
if I can be heard, I'm sorry, Judge.
Sure.
Thank you. Roberts has been in custody for several weeks. Excuse me, I had a frog in my throat. She does have a place to live. She lives locally. She would, I think, I'd ask the court to give her an opportunity to avail herself of using a scram tether to ensure that her appearance in court, as well as any testing or other monitoring provisions that the court would deem necessary to ensure her appearance. I'd ask the court to, her bond is set at $25,000 in this matter. I'd ask the court to, she does have a couple other matters that are pending. She has the matter in circuit court that Mr. Ward and I have also discussed. I believe her bond is $50 in that matter. Her bond's $100, I think, in a 14B court, 14B district court case where I think it charges illegal entry. So I'd ask the court to consider reducing this bond to something that she may be able to post with or personal cognizance with any conditions that the court deems necessary to ensure her appearance.
Response.
Your Honor, I would object to any change of bond conditions right now. Ms. Roberts also had a domestic violence case pending. I understand it was a final settlement and may have been dismissed yesterday.
It was.
That was a newer case, however. Ms. Roberts, this case is a bit older. It looks like looking at the previous notes, there was a bench court issue for $25,000 cash or surety for failure to report to court, as well as community corrections. I think a subsequent violation for community corrections as well. I'm concerned, obviously, about the substance use in this case. I don't think that, given her history of failure to appear and some new offenses in the interim and failures to appear on this case and other cases in the circuit court, that we can trust Ms. Roberts to, on her own, comply with court orders and show up.
Your Honor, the DV case was dismissed yesterday in my note.
Does she have any other things pending at this point or no?
No, just this matter, the illegal entry case in 14B, and there's a circuit court case with a $50 bond, Judge. There is a whole
$50 bond in her circuit court?
yes.
That was just because she had a bond in something else.
Yes, that's my understanding. It's a very old case. It was bench warrant. I think for some reason I don't think the bench warrant ever got on lien because the jail didn't know about it until it was brought to their attention during the pendency of this case.
Granted. Defendant's bond is set at $5,000 personal recognizance bond. Defendant is to report over. We'll do new community corrections test. She's to report over for once a week testing.
Okay, thank you, Judge, and we'll work on the other bonds as well. But thank you.
Thank you, Your Honor.
Thank you. False case, People versus Timothy Stevens.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Stevens, Your Honor, who's standing here to my right.
Sir, your name?
Timothy Stevens.
Thank you.
Your Honor, at this time, we'd ask the court to set this matter for a preliminary examination. Ms. Tana and I have it an opportunity to discuss it.
Everyone.
Ms. Tana and I have had an opportunity to discuss this matter, and we're going to set it for exam.
Discovery is complete.
Yes, Judge.
Board have their witnesses available the 15th.
I believe so, Your Honor.
All right. Preliminary examination in person, July 15th, 2025. 9 a.m. That's before Judge. Judge.
Thank you, Your Honor.
On continue.
15.
Court called case, People versus Leo Stringa.
And Alex Warren Green on behalf of Stringa. Can you state your name?
Leo Stringa.
Thank you. Okay. I have before me two plea forms. It's going to be pleading to 2 counts of in 2 different cases to retail fraud, second degree, the 1-year offense. On a successful plea to that charge, count 1 would be dismissed. There's also an indication that a case out of 14A2 which is a retail fraud third degree, would be dismissed upon a successful plea in these cases.
That's all right, John.
And that's our full understanding, Your Honor. Mr. Stringa is asking the court to consider a no contest plea to both of those counts.
Do I have reports? It does say no contest plea. Yes, I do. I saw these reports. Okay. All right. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give you the truth, the whole truth, and nothing but the true self you got?
I do. Leo Stringer.
Sir, it is this court's understanding that you are going to be pleading to 2 charges of retail fraud in the second degree. Is that your understanding?
Yes, it is.
All right. Those are misdemeanors, punishable by up to 1 year incarceration and or a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. You understand what a no contest plea is?
Yes, my attorney's described it.
All right. 2 things about a no contest plea. I have to make sure that you understand it. First of all, it means that as to each of these cases, you have no desire or do not wish to contest these charges. You understand that?
Yes, I do.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
And you understand also, sir, in one of your cases, the case ending in 5508, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court.
Okay.
You understand that?
Yes.
Basis for the no contest, please.
Lack of recollection, Your Honor.
All right. Sir, to the charge, I'll start with the 15th District Court matter. To the charge of retail fraud, second degree, let me just give you an offense date. Having occurred on November 20th, 2024 in the city of Ann Arbor, how do you plead?
No contest, Your Honor.
To that same charge, having occurred on November 20th, 2024 at 3825 Carpenter Road, that being the Meyer and Pittsfield Township, how do you plead?
No contest as well.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You signed an advice of rights form?
Yes, I have.
Any question regarding any of those rights?
No questions.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of the trial. You understand by pleading no contest, you're giving up those rights as well as all the rights in that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Actually, no, the probation that I was on I'm done with.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Has anybody threatened you or coerced?
No.
You're doing this voluntarily?
Yes, on my own accord.
And of your own free will?
That is as well.
The court has been provided and has reviewed University of Michigan Department of Public Safety and Security for their case number 24-903-06211, as well as Pittsfield Township Department of Public Safety report for their case number 24-19305. Any objection to the court having reviewed those reports?
None from the defense, Your Honor.
Okay. Based upon a review of those reports, the court would find that there's a sufficient factual basis to determine the defendant's guilt. Sir, you understand that if I accept your plea in this case, between the time of the acceptance of your plea and the time of sentencing, if there's misconduct committed by you as defined by the Michigan court rules, you would, 1, not be entitled to withdraw your plea, and 2, any resolution or evaluation regarding this case, the courts would not be bound by in terms of sentencing. You understand that, sir?
Yes.
All right. Is counsel aware of any other promises, threats, or other inducements that have caused this plea?
None from the defense, Your Honor.
Has the court complied with the court rule in both of these matters?
You are satisfied.
And the defense is satisfied.
Court will accept the defendant's plea of no contest to count 2 in both cases. Count 1 is dismissed. In the 15th District Court matter, a pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in the 15th District Court matter will occur on July 29th, 2025 at what time? 9 a.m. before Judge Balvo. In the other matter, court does accept the defendant's no contest plea to count 2, count 1 being dismissed. The pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in that matter will be July 9th, 2025, 9 a.m. before me.
So thank you. That's for you.
Bond in each of these matters will continue. Thank you.
Thanks, Leo. Thank you, Your Honor.
Thank you, Your Honor. Court calls case People versus John Terry.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Terry. Mr. Terry, could you state your full name when you get up here?
John Martin Terry.
Thank you.
And Your Honor, I believe the court has received a plea form as well as a signed advice of rights form. Mr. Terry will be pleading to an added count 3 of controlled substance use, and counts 1 and 2 will be dismissed.
That is what the court has in front of us. Is that a correct statement? All right, let's have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
John Martin Terry.
Okay, sir, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance.
Yes, sir.
That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You understand also, sir, that while I'm taking a plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes, sir.
All right. Understanding all of that, you still wish to plead guilty?
I would, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
I do, Your Honor.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding those rights?
None, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
None whatsoever, yes, sir.
Anybody threaten you or coerce you?
Not at all.
You're doing this voluntarily,
Yes, sir.
of your own free will,
Yes, sir.
and because you believe that you are indeed guilty of this offense?
I am guilty, sir.
On the date of August 9th, 2022, at the location of Prospect Road near Berkshire Drive in Superior Township, Washtenaw County, State of Michigan, did you have heroin in your possession?
I did, sir.
Had you used it?
Yes, sir.
And did you know what you were using was indeed heroin?
Yes, sir.
Sir, I do have to advise you that if I accept your plea, if there is misconduct committed by you as defined by the Michigan court rules between the date of this plea and the time of your sentencing, any plea agreements and or evaluations the court would no longer be bound by. You would also not be eligible to set aside your plea. You understand that, sir?
Fully understand that, sir.
All right. Counsel, are there any other pleas, threats, or inducements that have caused this plea that have not been stated on the records?
No, Your Honor.
Have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
July 15th, 2025, at 10 a.m.
July 15th, 2025, time 10 a.m. before Judge Barr.
Thank you, Your Honor. And may I address bond?
What would the case be if you didn't? Go ahead.
Your Honor, so we did discuss this last week. I would just ask you to consider again a personal recognizance bond for Mr. Terry now that he has pled to a single misdemeanor. He does now have reliable transportation to court in the form of his mother and his own transportation. He has a job at Tradesman that he could go back to. Again, he did admit that he had a slip up with regards to his sobriety, but he is committed to doing better. He's provided proof that he was enrolled in medically assisted treatment as well as mental health services through Packard Health and CMH prior to going into custody. And he had already completed an access interview with Home of New Visions and had planned to enroll in intensive outpatient treatment again prior to the bond violation, and would plan to do that if released, if Your Honor again would consider a personal recognizance bond.
So there's no plan set up for what he's going to do at this point?
There is.
It's my understanding that he was approved to participate in intensive outpatient through Home of New Visions. He would just need to contact them after he is released.
Anything from the people?
Your Honor, Mr. Terry has been able to provide through his counsel a proof of the treatment that he's been undergoing since February or March of this year. So we would leave it up to the court's discretion since he is.
Well, I'll tell you what, I'm going to deny at this point, but the reason my understanding is you would be shortly seen by 1482's probation. And certainly that can be then addressed by Judge Bars to his release. All right, consistent with what they see. So at this time, I'll deny your motion for bond modification. Bond will continue.
Thank you, Your Honor.
All right. Thank you, sir. Good luck to you.
Sir, thank you.
Court calls the case, People versus. Is it? You have Asher. No. What about, do you have Huffman? Court calls the case, People versus Orby Huffman.
AP Richmond, Deputy.
Your name, sir?
Orby Huffman?
It says Mr. Brown is the attorney.
Is represented by Mr. Burgess. Mr. Burgess is a substitute.
That is not what, when did that happen? This morning?
I want to tell you yesterday.
So where is Mr. Burgess?
He's not here.
We'll have to stand in that for adjournment, Your Honor.
It's new counsel coming in. All right. Sir, I don't have the public defender had to withdraw from your case. I don't know if they discussed that with you or not.
No, they did not.
Okay. The reasons, there's a conflict of interest. It looks like because of the public defender's representation or prior representation of the complaining witness in this case. Okay. So they would have to withdraw. They've withdrawn. The appointing authority has appointed Mr. David Burgess to represent you. Okay, we have not heard from Mr. Burgess this morning. Don't know where he is. Quite frankly, even if he appeared today, he probably wouldn't have everything to be able to and have talked to you to make an intelligent decision as to what to do with it. Okay. And so he'd likely asking for an adjournment anyway. So what I'm going to do, that's a long way of telling you, I'm going to adjourn your case out 1 week. Make sure Mr. Burgess has everything that he needs and then he has the opportunity to come talk to us. Okay? Probable cause conference will be adjourned 1 week to July 10th, 2025, 9 a.m. Bond will continue. Thank you, sir. Court calls the case People versus Tariq Wilson.
For the people.
Morning, Your Honor. Andrea Stammer requesting permission to practice pursuant to MCR 8.120 under the supervision of Assistant Public Defender Chinaza Akiri Ekenroli.
Is this the only thing she gave you today?
It's a
What?
list,
Really?
Your Honor.
It's the only thing she gave you?
Yeah. So far.
She's just been wandering around back there, like lost. And you didn't give her anything? Okay, fine. Anyway, your client's not here because he's not behaving himself and the facility would not sign in. Okay,
That's correct, Your Honor. At this time, we are requesting an adjournment for negotiation purposes.
okay, very good. Conference will be adjourned to the 17th, 2025 at 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. One case, really, Chanel? One case. One case. Court recalls case People versus Thomas Basher.
Austin Gilbase on behalf of Mr. Thomas Vasher, who is present to my right, Your Honor. Mr. Vasher, can you state your name for the record one more time?
Thomas Bashan.
Standing is that the defendant will be pleading guilty to count 2, the receipt and concealment of stolen property less than 200, which is a misdemeanor punishable by up to 93 days in jail. Upon a successful plea to that charge, count 1 would be dismissed.
That is a correct reflection, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Thomas Basher.
Sir, it is this court's understanding that you are going to be pleading guilty or no contest to the charge. No contest to the charge of receipt and concealment of stolen property less than $200.
Yes, Your Honor.
All right. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. First thing is it means that you're not further desirous or wanting to contest this charge.
Yes, Your Honor.
Second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty.
Yes, Your Honor.
Basis for the no contest plea?
Potential civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights? Look at paragraph 5. You say, those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No. Not that.
No. Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes, Your Honor.
All right. Court has been handed and has been provided and has reviewed Washington County Sheriff's Office report for their case number 255214. Any objection to the court having reviewed that report?
No objections, Your Honor.
All right. Sir, I do have to advise you that any sentence evaluation and or agreement regarding your case, if you were to commit misconduct from the time I accept your plea to the time of your sentencing, that the court would not be bound by that. You understand that?
Yes, Your Honor.
You understand also that if you commit that misconduct, you would not be entitled to withdraw your plea.
Yes, Your Honor.
You understand that, sir? All right. Counsel, based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Is counsel aware of any other promises, threats, or inducements which caused this plea?
None, Your Honor.
Has the court complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
The defense is satisfied as well, Your Honor.
Court will accept the defendant's plea of no contest to this charge. To count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing in this matter will be
July 21st, 2025 at 10 a.m.
July 31st, 2025, 10 a.m. That is before Judge Washington.
Here, may I address bond when appropriate?
If you want to, go ahead.
Your Honor, now that my client has dealt with this case, the only other case that we'd be holding him is a driving without a license case out of.
What?
Now that my client has dealt with this plea and the felony was dismissed, my client is asking to be released on a PR bond. The only other case that he has currently is a license case out of 14B.
And I would already given that would be reduced to the PR bond.
Yes.
If I was reinstated.
Response?
Your Honor, given that felony is now gone, I don't necessarily object to the court reconsidering bond. However, I would you have 3 pending board requests, one for fleeing third OUND in March, a RNO in April of this year, and a enforcement in the building from May of this year. At the time of this offense, the defendant was in abscond status from circuit court probation.
Your Honor, my client asked that he once again be given a PR bond. If the court deems it appropriate, he can go on a tether. He has no issue doing that. He just wants to get out, hopefully get back to his job. His girlfriend was here for support, but she
Mr. Basher, it really is not helping your cause to sit there and try to mouth anything to me. All right? Because I'm trying to listen to your attorney and not pay attention to you.
Yes, Your Honor.
He does have some support here. She was here in the court waiting for him for about 3 hours, but she had to leave. As I said, Your Honor, the only other matter that would be holding him is a driving case. And these other charges that are pending have been pending for a long time. We haven't got anything. So
Are those going to be coming forth anytime soon or what?
I made the APAs who are assigned to those warrants aware, and they look very chargeable to me, Your Honor.
Also, Your Honor, my client has been in custody for 45 days now.
All right, I will grant the defendant's motion to modify his bond. I'll set his bond at a $10,000 personal recognizance bond. Defendant may be released on a GPS tracking tether prior, or can be released only with the GPS tracking tether in place, location tracking.
Understood, Your Honor. Thank you.
Thank you. Court does call the case People versus Virgil Dunlap.
Here, hearing on behalf of the people.
Edward Drickus for Virgil Dunlap. Your Honor, please state your name.
Virgil Dunlap, you know.
I was appointed yesterday. I obtained the written discovery. There's some outstanding video discovery that I'm going to ask for an adjournment to obtain.
Probable cause conference will be adjourned July 17, 2025, 9 a.m. Bond conference. Court does call the case People versus Elton Bell.
Secretary Ward on behalf of the people.
Kevin Datish on behalf of Mr. Bell, Your Honor.
Wow, it's been like 2 hours now since I left. Go ahead. I'll let you go.
He's answering my phone calls. He said his ride is just not answering his phone. I would like to ask for an adjournment. He literally was going to come here, make a payment for his.
You want me to send a car for him?
I can help him with that next time. He doesn't have transportation. He's relying on people who used to work for him in the past to get here. I'm even inclined to have him learn Zoom so he's able to attend, so we don't have to worry about this in the future. I don't believe he's ever not appeared before, based on my notes.
You don't know.
So we are going to be asking for an adjournment, Your Honor.
Your Honor, this is a larceny case where the defendant took a check from the victim for $2,000 and for over a year, they were thought around to do the work, I'll pay you back, sort of thing. And here he is supposed to show up and pay some money for a misdemeanor offer, and he doesn't have a ride. We haven't seen photographic proof of him not having a ride. So
I don't know what that photographic proof of somebody not having a ride would be.
Well,
Me sitting in my house?
He suggested it.
I don't know. It's a running joke.
Yes, that was.
And Your Honor, he is 65. He receives quite little Social Security. He doesn't work. He has injuries. We're trying to provide. He was going to come with documentation of his injuries.
Are you on the docket next week?
I should be.
Okay. So what
You will show
I'll do is
up.
I'll adjourn it out a week. If he doesn't show up, then I take you into custody.
I'm okay with that.
You're okay?
Yeah, thank you, Your Honor.
Good.
She is good with that.
Sounds like she is?
Yes.
Oh, yeah. He's just like, yeah, she'll be.
Now she's gonna, even if we're off, I'll be here.
Probable cause conference, July 10th, 2025, 9 a.m. Fine.
Thank you, Your Honor.
Mr. Dish didn't seem to care, did he?